Yes,
So,
it's okay.
thanks. So I heard Singapore so many times, was mentioned so many times today. So my topic will be related to the new Payment Services Act of Singapore and its practical application. This act was just came into operation earlier this year, while it was passed by the Parliament early last year, but it was pending payment services regulations, which were being prepared by the Monetary Authority of Singapore, which is the authority that is overseeing the act and which is regulating all the payment services, all the activities that are regulated under this act. I wanted to mention here that the Monetary Authority of Singapore, I will call it MAS, it's a shorter version, it's a shorter form of the central bank in Singapore. MAS and Payment Services Act gave the firms that are already operating in the regulated activities, they gave them an exemption period to get license, and this exemption period starts from 20th January, and it's given to the, for example, digital payment token service providers. Exemption period is 6 months, and for other payment service providers, exemption period is 12 months. So what are the new types of licenses introduced under the PS Act? The only license that was kept from the previous legislation that is mentioned on the previous slide is Money Changing Remittance Business Act and Payment Systems Oversight Act is a money changing license, and the new types of licenses that are introduced under the PS Act are called Standard Payment Institution License and the Major Payment Institution License. The difference between two payment institution licenses is in the thresholds that are established by the Act, and for the Standard Payment Institution License, it is mandatory to make sure that they are within these thresholds. Otherwise, they will have to change their license to the Major Payment Institution License. So the thresholds are also presented on the slide. And they're different for the different types of services regulated under the PS Act, which are shown on the next slide. So also, PS Act is started to regulate some new services which were not regulated under previous legislation, and such services as account issuance services, e-money issuance services, and of course digital payment token services that are introduced as being regulated under the PS Act. They were not regulated or were regulated in a different manner previously. For example, account issuance service and e-money issuance service was under the ambit of Payment Systems and Oversight Act. And basically, if you are not transacting like 30 million Singapore dollars value on a daily basis, you are not required to be registered or licensed by MAS under the previous act. Currently, you are required to be licensed and to obtain either Standard Payment Institution License or Major Payment Institution License, depending on the value of transactions and on the volume that you are intending to operate or already operating. Excuse me. I put this as a comparison, these two definitions as a comparison, because it's very interesting how MAS defines e-money and digital payment tokens, and how MAS defines them differently from all other jurisdictions. For example, how it is defined in Europe and how it is defined in any other countries. And another reason for putting these definitions together is that currently MAS is undergoing public consultation on the definitions and on the terms, because if you look at the definition of e-money and digital payment tokens, if you look at the definition of digital payment tokens, you can see that it should not be denominated in any currency, or it should not be pegged by the issuer to any currency. But we know some examples of tokens that are backed by the currencies. For example, Tether. It's the most famous example of cryptocurrency that is claimed to be backed by US dollar. So one Tether is $1. But it means that based on the definition of digital payment token currently presented in the PS Act, it won't be caught by the PS Act. So MAS is looking how to improve the definitions to include into the ambit of the PS Act, for example, stable coins or asset-backed coins, tokens and coins, and to see how if they will fall under the definition of e-money, for example, or digital payment token. So that's basically the reason why I draw attention to these two definitions and how they are different, and how MAS is trying to distinguish e-money and digital payment token and regulate them in a different manner, in a different way under the PS Act. So what types of services, digital payment token services, are regulated currently under the Payment Services Act? There are two types of digital payment token services. One is dealing in digital payment tokens, and second one is facilitating the exchange of digital payment tokens. So dealing in digital payment tokens, or DPTs, is defined as buying or selling DPTs in exchange of money or any other DPTs. While facilitating the exchange of digital payment tokens means establishing or operating a DPT exchange for the purpose of offering and inviting to offer to buy and sell DPTs in exchange of money or any other DPTs. Also, PS Act excludes certain types of DPTs from its regulation, and these types of DPTs are limited. They're calling it limited purpose digital payment tokens, and they provide examples of two types of these DPTs. For example, in-game assets or rewards, and they exclude them because of the nature of these tokens, and they exclude them on the basis that they cannot be returned to the issuer, and they are used only for limited purpose. For example, in-game assets, they are used to exchange only in the game by which it is they are issued, and rewards, they are also used for only for the purpose of exchanging them for the goods and services of the issuer. Also, currently, MAS issued another public consultation seeking public view on regulating more digital payment token services. And they are asking if, for example, custodian services related to DPTs or service providers that are providing services for transmissions of DPTs from one DPT service provider to another DPT service provider, or service providers that provide safeguarding or administration services in relation to DPTs, whether these types of services should be also regulated under PS Act. So as of now, it's public consultation paper is issued and the responses are collected, but MAS is working on providing the feedback for the public responses, and we are waiting for this feedback to see if the PS Act will be changed further. And it seems that current version of the PS Act will be changed in the next few years, and it's the law. This act is going to be very flexible and movable, and it's not like, for example, Securities and Futures Act, which is where the changes are very minimal, and usually it's a big deal for Singapore to change the Securities and Futures Act. I don't think personally that this will be the same. It will be the same for the PS Act, and it seems that it's the act itself is work in progress, and MAS is trying to adapt the fast-paced environment and payment tokens, digital tokens environment, and try to catch this and to catch as much as possible under the PS Act. So what I put here in this slide the admission criteria, which are different from the admission criteria that are same for across all the regulated activities under any of the acts that are administered by MAS. And excuse me. And what is different under the PS Act? First of all, the governance requirement, which require you to have the applicant to have at least one executive director who is a Singapore citizen or permanent resident, or at least one executive director who is a holder of working visa in Singapore, which is called Singapore Employment Pass. And at the same time, it must be at least one other director who is Singapore citizen or Singapore permanent resident. This is much different from the requirements, governance requirements under the, for example, Securities and Futures Act, and for the applicants to the capital market services licenses, where the requirement is just that the executive director must be resident in Singapore. Here they require that it must be Singapore citizen or PR, which is a higher threshold to meet, or Singapore EP holder, and one other director being Singapore citizen and PR. Of course, MAS will never accept nominee directors, and they're making it quite clear in any guidelines, in any papers that they release in terms of admission criteria. They always mention that nominee directors in any role, in any advisory role, company secretary role, any other roles, will not be treated as directors for the purpose of the application. Another admission criteria that is different is compliance arrangement. So MS requires you to have in place an independent compliance function in-house, or outsourced, or being outsourced to the parent company or related entity, which can be an overseas entity. While under other regulatory regimes, the requirement is broader, and the applicant may outsource it to any external service provider. So MAS tries to make sure that the applicant will comply with the regulations under the PS Act fully, and that's why they require that the compliance function is internal or outsourced to the parent company, so it's within the same group. Another requirement that is different is technology risk management. It's for online financial services, and most of the PS applicants under PS Act, they will be providing their services online, unless it's money changing business, which is exchange of notes to other notes. So MS requires them to do penetration test and comply with technology risk management and cyber hygiene requirements as a must, and to confirm this to MAS. And also I need to mention that requirements under the PS Act, technology risk management requirements under PS Act, they are quite high, and they are very similar to those that issued to, for example, to banks or other financial institutions in Singapore. And for example, the recovery time objective must be the same as for the bank in Singapore. Another new and special requirement for the DPT service providers is to have a legal opinion on the applicant's assessment of the nature of each token supported by the service provider. So service provider must attach this legal opinion to the application form. It can be any firm, any law firm that issues this legal opinion. In Singapore, it must be local law firm, and this is one of the mandatory requirement to the special mandatory requirement for the DPT service providers. MAS is also working in this direction, and they last year during the Fintech Festival they announced an initiative which is called Payment Regulatory Evaluation Program, or PREP, and it allows the DPT service providers to choose the law firm from the list of participants of this PREP program, which is available on the website of the Law Society of Singapore. Just wanted to mention that the law firm to which I am seconded to was one of the 7 law firms which was invited to develop the standards for this PREP program, and we are quite close to MAS, and we are quite close to understanding what are the requirements of MAS in terms of application under the PS Act. Also, I wanted to mention that there are special ongoing requirements for the digital payment token service providers, and they are, of course, they are related to anti-money laundering and counter-financing of terrorism, and they are special also because they are Singapore went quite beyond FATF recommendations and MAS requires the applicant to perform customer due diligence from the first dollar of digital payment token transaction, even if the transaction is occasional. They're explaining this by the fact that even if the transaction is occasional, it is very easy from their point of view to split large DPT transaction into a series of small transactions, which will be below the threshold, whatever threshold they will set, and then such customer will just bypass the due diligence and KYC, and it is a threat to MAS because it might be a fraud or money laundering transaction. So in order to prevent this, they basically removed any thresholds, and DPT service providers must perform customer due diligence even on occasional transactions and on every customer, even from the first dollar of transaction. Also, digital payment token service providers, they are required to disclose risk warning statements as specified in the Annex A of the Notice of Disclosures and Communications. It's one of the notices that was developed by MAS. There are more than 10 notices, and which is all coming under the payment services regulations, notices and guidelines. So DPT service provider needs to publish risk warning statement at least once. That must be publicly available on their website or in any material that is issued by the DPT service provider. Also, this statement must be provided to the potential customer prior using their payment services. It must be clear and separate from any other statements, any other information provided by the by the DPT service provider. And the risk warning statement sounds like stating that the DPT service provider is licensed by MAS, but it doesn't guarantee that in case of cessation of business, the customers will be returned their money. They might lose their money. Also, if the customer is not familiar with the DPT transactions, they should not be involved in the DPT transactions, and they should be aware of risks related to them. One of these risks that is included in this risk statement is that the value of digital payment tokens is highly volatile, and that the customer may lose their money and they have to be prepared to lose their money if the volatility is too high from minute to minute. That's all that I wanted to share with you in terms of New Payment Services Act in this short period of time, and I'm waiting for your questions.